Picture this. You've been living peacefully in the United States for years, maybe even decades. Your immigration case was administratively closed long ago, and you thought that chapter of your life was over. You've built a life here. You have a job, a home. Maybe you're even thinking about marrying that special someone who happens to be a U.S. citizen. Then one day, out of nowhere, you receive a notice that changes everything. Your case is being reopened. The nightmare you thought was behind you is suddenly front and center again. Hi. I am attorney Jae Francis. I am a U.S. immigration lawyer based in Chicago and Wisconsin, but I serve all 50 states. And I'm here to tell you something that could save your life as you know it. Your administratively closed immigration case could be reopened tomorrow. If you're thinking about marrying a U.S. citizen or already have, this could either save you or destroy your chances at a green card. The Trump administration is aggressively reopening hundreds of thousands of old cases, and what you do right now could determine whether you stay with your family or face deportation. In the next few minutes, I'm going to explain exactly what's happening, why it's happening, and most importantly, what you need to do today. Not tomorrow, not next week. Today, to protect yourself and your family. We're witnessing an unprecedented assault on immigrant communities through the systematic reopening of administratively closed removal proceedings. The Trump administration has launched a campaign to reopen nearly 400,000 cases that were closed years, even decades ago. Immigration attorneys nationwide are scrambling as they receive DHS motions to reopen cases from 10, 15, even 20 years in the past. This isn't random, it's strategic. The administration views these closed cases as low-hanging fruit to boost deportation numbers. Since many people with administratively closed cases lack clear paths to permanent status, the government believes they can quickly win these cases. In April 2025, the Executive Office for Immigration Review rescinded previous guidance on administrative closure, eliminating protections that kept families together. Combined with expanded expedited removal and the invocation of the Alien Enemies Act, the government has created multiple fast-track deportation pathways that bypass traditional court hearings. The human cost is staggering. These aren't criminals. DHS rarely close cases for people with criminal records. Instead, these are parents of U.S. citizens, people with serious medical conditions, essential workers who've contributed to their communities for decades. They built lives here, believing their immigration nightmares were behind them. Now, they're being thrust back into a system designed to deport them as quickly as possible. Administrative closure is immigration purgatory. Your case isn't active, but you're not safe either. When removal proceedings are administratively closed, they are temporarily removed from the court's active calendar. You can often work legally and remain in the U.S., but you haven't received permanent status. It's like pressing pause on a ticking time bomb. Here's the critical part most people don't understand. Administrative closure can be reversed at any time. There's no statute of limitations. A case closed 20 years ago can be reopened tomorrow. And under current policies, that's exactly what's happening. DHS is systematically reviewing old files, filing motions to recalendar cases, and putting people back into active removal proceedings. The most dangerous aspect, many people don't know their cases have been reopened until it's too late. If you miss your court date because you never received notice, the judge will order you deported in absentia. That's why checking your case status regularly isn't just recommended, it's survival. Use the immigration court website with your A number weekly. Update your address immediately using Form EOR 33 with both the court and DHS. Contact any attorney who ever represented you, even if it was decades ago. Your life may depend on receiving that notice. If you're married to a U.S. citizen or considering marriage, the reopening of removal proceedings creates a complex legal minefield. Getting married while in proceedings triggers the highest level of scrutiny. You must prove by clear and convincing evidence that your marriage is genuine. A much higher standard than normal marriage cases. The government presumes fraud unless you prove otherwise. Here's your strategic pathway. First, your U.S. citizen spouse must immediately file Form I-130 with USCIS, explicitly requesting a bona fide marriage exemption in the cover letter. Without this exemption, USCIS cannot legally approve a petition filed after removal proceedings began. Include overwhelming evidence such as joint bank accounts, lease agreements, insurance policies, photos throughout your relationship, affidavits from friends and family who've witnessed your relationship develop. If you have received an I-130 receipt notice, you may notify the immigration court that you are pursuing a form of relief from deportation. Once your I-130 petition is approved, it is important to promptly file a motion with the court to resume your removal proceedings. This step allows you to seek adjustment of status based on the approved petition. Under the Trump administration, courts rarely grant requests to terminate removal proceedings, so you will most likely need to apply for adjustment of status directly with the immigration judge during your proceedings, rather than hoping to have your case closed. However, if you entered without inspection, adjustment through the court may be impossible. You'll need consular processing abroad with a waiver for unlawful presence, adding risk and complexity to your case. Time is your enemy in this new enforcement environment. Every day of delay increases your vulnerability. Here's your comprehensive action plan starting today. First, verify your current status. Check the immigration court website using your A number immediately and weekly thereafter. Many people discover their cases have been reopened only when ICE arrives at their door. Don't become a statistic. If you can't find your case online, contact the immigration court directly. Sometimes older cases aren't in the online system. Second, secure legal representation immediately. This isn't optional anymore. The immigration court system has become exponentially more hostile. Judges are under pressure to move cases quickly and deny relief. In March 2025, judges denied 76% of asylum cases, the highest rate ever recorded. Without an attorney, your chances of success plummet. If you can't afford private counsel, contact nonprofit organizations. But don't wait. Resources are limited and demand is skyrocketing. Third, build your defense now. Don't wait for a reopening notice. Gather every document that supports your case, such as tax returns proving you've contributed to society, medical records showing conditions that would worsen if deported, school records for U.S. citizen children, letters from employers and community members. Create multiple copies and store them securely. If ICE detains you, your family needs immediate access to these documents. The immigration system you might remember from years ago no longer exists. The Trump administration has fundamentally transformed immigration courts into deportation machines. Understanding this new reality is crucial for survival. Judges face intense pressure to clear backlogs by denying cases. The administration has fired judges viewed as too lenient and appointed others who align with enforcement priorities. Due process protections have been stripped away. The expansion of expedited removal means many people never see a judge. Even if you reach court, you'll face a system where 76% of asylum seekers are denied and where marriage-based cases receive extreme scrutiny. If your case is reopened, you have limited options but must pursue them all. File a motion opposing reopening within 10 days, arguing why your case should remain closed, such as your community ties, U.S. citizen family members, medical conditions, or the simple passage of time. Simultaneously, pursue any available relief. If you have a potential asylum claim, prepare it. If you're married to a U.S. citizen, file immediately. If you've been here 10 years and have qualifying relatives, explore cancellation of removal. Don't abandon any option until another is secured. Most critically, never miss a deadline or court date. The system is unforgiving. One missed appearance means deportation. One late filing means losing your chance to present evidence. Set multiple reminders. Have family members also track your dates. Your future depends on extreme vigilance. This video could save someone from deportation. If it helped you understand the crisis of reopened cases and your options, please like and subscribe immediately. Share this video with anyone who might have an administratively closed case. Their life could depend on seeing this information today. I know you might be thinking, I'll share this later, or I'll save it for when I have time. But there is no later for thousands of families facing this crisis. Right now, someone you know might be living with an administratively closed case, completely unaware that DHS is actively working to reopen it. They might be planning their wedding, saving for their children's education, or caring for elderly parents, having no idea that their world is about to be turned upside down. By sharing this video, you could be the person who gives them the warning they desperately need. Comment with your questions below, but remember, YouTube isn't legal advice. Your case needs personalized attention from an attorney. Don't wait another day. The knock on your door could come tomorrow. Take action now while you still can. Your family's future depends on what you do today.